Really?
Great. Hi, everyone. Welcome to the House Democratic Caucus. Friday, May 15th. We're here to talk about S212. We have an amendment from Representative Greer, so we're going to have him come up and present his amendment. And then we'll have the committee talk about why they voted the way they voted and what they heard in committee. And the hope is to be back on the floor close to 1 and not a little bit after. So what else? And I should say, sorry, I'm Lori Hogan, representative.
Hi, Lori. Representative Will Greer Bennington. So my amendment to S212 is essentially it's a study committee to determine if our isolation distances and the way that we do overshadowing in our state, if that's still an acceptable practice, and if so, how would we financially compensate landowners who lose the ability to use their land the way they want? The way it works right now is it's first in time permitting. So the neighboring property says that they want to put a septic system in, for example, and it overshadows onto the neighbor's property. The neighbor next door will no longer be able to develop it the way they deem fit. And so what I've been hearing from constituents back home is that there should be a financial compensation piece to this. A&R studied this, I believe in 2010 was the last major report. They've indicated that they're still wanting to work on this issue because it's affecting a large number of landowners around the state. And I think we need to have a resolution for neighbors to be able to resolve this peacefully. Many neighbors may be able to work it out, but there are a lot of cases where it becomes heavily litigated and there is no way to resolve this. So that's why I've introduced this amendment. So if they come back and they say that, it should continue the way it is, well, then we'll hear that in January of 27. But they may come back with something different and propose an alternative. So I think that it's worthy of consideration. Give A&R the focus to really dive into this. Again, it's been 16 years since we've had a really comprehensive report on this. So I'm urging for support for it. But I'm happy to take questions. May I take questions?
Yeah.
Oh, anyone
Have questions for Will?
Are we
Oh, sorry.
Yeah,
Oh,
Candace
you
is,
want me
Candace is helping us out.
Representative Bishop of Colchester, you referenced that the neighbor, if they're in an overshadowed area, if you will, their property from the neighbor who's putting in septic or well, that they can't develop at all. Is it that they can't put in their own well or septic, or they can't do anything? They'd be able to put an expansion on their house?
Well, that's all context dependent, probably not in that situation of extending, building an ADU or building a shed, because that would not be allowed.
Anyone else?
The process, could you describe the process of, maybe perhaps I need to drill in the well on my property? It's gonna be next to my neighbor's property. There's gonna have to be a protection zone around that. There's a process where that neighbor's told and there's, a piece that goes, so it's not like they're unaware.
Yep. So this right here is the notice form that they get. I believe this is still the same one that they use, and it was published on DEC's website in 2012. It's still the current form that they use. So notice was provided in 2010 after that report, but there's been no follow-up to the financial compensation component.
Thanks very much. Jonathan Cooper and panel. The question I have is to do with the technical advisory committee law such. Is it currently meeting? Does it do this stuff every year? And why does legislation, why does an amendment need to exist if it's something that the technical advisory committee could just be asked to do?
So the technical advisory committee does meet quarterly, I believe. I'm looking at Representative Sheldon. Yeah. They have an overshadowing committee. And I think the reason why there should be an amendment on this and really to put the pressure on it is because, again, there's been significant delay in this and they have not done this in 16 years since that original follow-up. So.
Okay, great. Thank you. All right. I think we're turning it over to Representative Chapin.
Sure, I'll start. I guess I want to start by saying there is a lot there's a fair amount in this amendment. And when I look at the amendment and just want to share sort of what we heard in committee is that subsections A, 1, 2, and 3A are really already settled science. So we really know that isolation distances are necessary for public health. And we know that the overshadowing is just a reality. And re-looking at that and tasking a task force, the TAC already meets regularly, as you just heard. They also have subcommittees that meet on different topics that meet regularly. And tasking them with re-looking at the science of isolation distances would be a bunch of workload on a committee that has already limited capacity and lots of really important work in front of them. So certain subsections of this would be asking them to do work that we really do not believe they should be doing. They've already done the work. We know it's settled science about isolation distances and public health. Subsection A3B has been done. It has to be done on a case-by-case basis. And that piece is tasking the TAC to look at an explanation of why alternatives that do not encumber the property of others would not be feasible. And that piece is really a case-by-case. We heard that very clearly from the experts in the room. So I wouldn't want to be asking them to do this kind of work when it doesn't make sense. Subsection A3C is the issue at hand that I think we all sort of share. There's a concern around the fact that property owners that have these overshadowing are left to their, largely to their own devices to figure out. Often it's just a handshake. Great, I have plenty of property. Your overshadowing onto my property is not a big deal. I don't ever plan to do anything. It's too rocky. I can't really build there anyway. Great, handshake. Thank you. So I just want to clarify, I don't know if this was said by Representative Greer, but when an overshadowing would, when the siting of something like a wastewater system, septic system is being done and they're looking at designing it and it's clear that it would overshadow into another property, during that permitting, early in the permitting process before a permit's issued, the property that's being overshadowed gets a notification from the agency. So I just want to make sure people understand that. And that, I'm sorry if that was already said. So that notification is sort of the tool that we're currently using to initiate good communication between neighbors and some kind of resolution. And I think what the problem that Representative Greer is identifying that has been known for like 16 years is that sometimes that is not a big deal and it just leads to a good handshake and communication between neighbors and it's not a big deal. And sometimes it is a big deal and it often, and in those cases, it can result in litigation. And so currently the system is that these things are getting figured out. The difficult situations where there is really a conflict, in those cases, which are probably not the majority, we didn't get any data on how many we see in either of those camps, but when there is more of a conflict and it isn't, and adjacent property owners are not happy about that, that's when it does go to court. And so it can result in compensation. That is a current outcome in some of these cases. And so, but right now there's no standard. Should everybody be, I think what Representative Greer is saying is, should everyone always be compensated? Should there be some clear standards? Should there be statute that guides that rather than the current process, which is neighbors figure it out. And if it needs to go to the courts, that's where it ends up. So that's sort of a big, important question that this amendment raises, or one. And I'd say that right now, subsection A3C tasks the TAC at ANR to help address that question. And one thing that we raised in our committee is this really the jurisdiction of our committee, and is it the jurisdiction or the appropriate topic for a group of largely scientists and people who have expertise in a certain area to be figuring out how to deal with neighborly conflicts that involve compensation? Or is this really more of a judiciary? Like, I think there's a real problem to be solved here, but I don't think the TAC, like what our committee heard and what the majority voted on, is that the TAC isn't the right entity to really weigh in on how to deal with these kinds of conflicts and whether compensation should be the standard or not. And then I just want to move on to say, well, before I leave that section, ANR also said that they'd be happy, like this subcommittee that deals with isolation distances does meet regularly. They've been talking about these issues. This is something they already speak about. They report to us annually on January 15th already in writing. and that they'd be happy to really address the core question in subsection A3C on January 15th next year. And they made that commitment to us in our committee room. So do we need to legislate that or not is part of the question here. And then I want to just finish the amendment subsection A4. The majority vote did not find applicable since the science is settled on isolation distances and public health, and that piece dictates what the TAC would report on if they decide that isolation distances are not necessary in the current way. So there's just a lot of the amendment that I think our committee doesn't support, and this one piece around getting at the core question, we are interested in hearing back on that and are committed to doing that. And we are going to need to hear from parties that are not the TAC and not ANR on what is really about conflicts and litigation. Anything, Amy or Larry, did you want to add?
Here, let me get you or you come over here and use another way.
I would just say that Ella did a really great job of telling us why the committee found the amendment unfavorable. And I would only want to emphasize that we heard from ANR that the TAC really isn't the right body to be considering the questions around compensation, which is the motivating driver of the amendment.
I think I kind of step back a little bit, if I may. And I have a response from ANR on the first amendment that we got that I think sheds some light on how the committee is moving through and responding to the proposals of amendment. As you see from Brian Redmond, the director, division director for drinking water and groundwater protection division. Thanks for reaching out. This is regarding the Olson Amendment, but it sets the stage. Thanks for reaching out as the amendment is significant. It appears the contents of the amendment are similar to the proposal I reviewed with you and Rep. Olson prior to the session starting and what ultimately became H746. Despite some of the changes that have occurred in the amendment, ANR has concerns about the underlying scientific and technical justification for many of the key technical provisions of the amendment. Additionally, the work required to develop the technical and scientific justification for these changes is significant and will require both human and financial resources to implement, which we have not planned. For these reasons, ANR does not support the amendment. S212, if passed by House Environment, will reduce the administrative burden and costs associated with the current permitting process while creating a more efficient framework over the long term. However, implementation of this new framework will require a substantial upfront effort by the program, including development of the connection design manual, establishment and public notice of a new general permit, creation of supporting policies and procedures, and development of the electronic forms and technology needed to support the new permitting and delegation system. Our existing permitting responsibilities, which has our capacity stretched, will continue uninterrupted during this transition. The program is moving forward without additional resources because we believe this modernization is the right path and will ultimately improve efficiency, resource allocation, and outcomes statewide. Our current plan is to focus on the connections work the legislature is directing us to do, with the hope we can leverage this work to quickly expand the types of general permits we issue for which the legislature is granting us authority. I just think it's important to realize the underlying bill is doing a lot of very good things that folks want done. Our Agency of Natural Resources is working in good faith to address some concerns that have come up over the years, and to ask them to do more in different directions is unrealistic. So if we want to expedite permitting for housing, please support S212 and don't get distracted by amendments.
Okay, any questions? I thought you were doing it. You can do the next one. Go ahead.
Jonathan Cooper again. It seems like the TAC is the entity that did the work in 2010. Yeah, and it's ongoing, but it's what Representative Greer is referring to is a document that was issued in 2010. And The claim, I think what I heard from that email is a state employee who has a lot on their plate already and is saying that this is more and we don't have funding or the human power to do it. Is that?
Yeah, actually, hold on. So I didn't read the follow-up, which is in response to the Greer amendment. I asked if they would come in and speak to it, and he said, yes, I will express the desire of the committee and my direction for the TAC to consider the concepts in the Greer amendment, which we asked them on the record, would you take this up? Yes, they said. I do agree that the issue of compensation will be challenging for this committee to make firm recommendations regarding, but they are an experienced group of practitioners, and I do think their analysis could provide some insight. I'm also planning to ask them to evaluate procedural options that go beyond just notification in instances of overshadowing. Please let me know if you have questions or concerns.
And so was there time to consider what if it's not that if the charge is over the ground, can it be reduced? And is there any knowledge of who the appropriate entity would be if it is not the technical advisory?
No, we didn't have time for that, but we did get to a really good point that I think, which is it's actually in many ways an area outside of our jurisdiction. It's actually judiciary or maybe GovOps for compensation. I don't know. It's not, our job is actually to keep people from polluting their own and others' wells. And that's what Representative Chapin mentioned. The science is clear. This is a permitting system that is working. It has enabled our historic villages to develop further and safely with understanding of modern science and how we have polluted each other's wells and our own wells over time. Added to this is, of course, with PFAS being a new and interesting challenge for all of us, we need isolation distances between our septic and leach fields, or between our leach fields and our wells, because it's now shown that our leach fields have the ability to put PFAS into the groundwater and into our wells. So actually, isolation distances are even more important now, perhaps than ever.
Other questions?
Yes.
I just had a clarification question, and this may be for Representative Greer, just understanding the current practice. Representative Chapin talked about there's a neighborly handshake in some situations. Are there any deed changes, or is there monetary compensation that sometimes happen? I mean, is it happening in a lot of different ways right now and there's no kind of real clear path? And I'm also wondering, is this coming up because, I mean, I would imagine that somebody buys a property, there's an overshadowing on it, they don't like it, they want something different. Is that why this is coming to light now?
I can just confirm that there are a lot of different ways this is getting worked out, and I am not aware if it's on the deed, so somebody else might be able to answer that.
And I'll give my best background information, having my family be entitled to insurance. It is not, the deed is still in the person whose property is affected. Again, this notice that was talking about, it does not require consent of the property owner if they do not want to allow overshadowing. So I don't know, did that answer your question? But yeah, no, the deed is still in the person's name. It limits their ability to do what they want with their land, and therefore does devalue it, because no one's gonna buy a parcel of land where they can't develop it. It minimizes the value.
We do have one more amendment to discuss. Are there any more questions?
Hi, Charlie Kimball, representing Woodstock, right? I heard Representative Greer say that, and I know in many real estate transactions that the deed is on the negotiated land, someone's selling a piece of land, they have that septic system on another piece of land, and that person actually does give that easement as well as water rights or access to water rights. So it's not always the case that it's not permitted, it's just, it does happen.
Okay, we're good. I should use this. Okay, any other questions? Otherwise, we're gonna move on to next amendment. That's not too bad. And then just squirrel alert before we go to that vote. Sorry. Oh, the vote. The vote on this.
7-4 unfair.
7-4 unfavorable on those amendments.
Greer amendment
Oh,
today,
7-4.
7-4 the other day.
7-4 unfavorable.
7-4 unfavorable the other day for Representative Greer's amendment, and now I'm gonna talk about.
Okay, wait, hold on. Just before everyone starts leaving, okay, you want, just for alert.
Let's go. There is most likely an amendment on 208 coming, so just pay attention because we will wait for caucus again if that happens. So just pay attention to what I say on the floor and your emails.
All right, I'm gonna talk about another amendment that we have on S212 submitted by Representative Taglivia, Representative Greer, and Representative Lipsky. I guess I need to explain what it does. It's a little confusing. It takes so it's attached. So one of the big challenges, I'll just say, so it might be helpful for me to start my notes about what the challenge is. The challenge here is that this amendment really should be on wetlands permit. It's about wetlands permitting, and it really should be attached in the wetlands section of statute. But because it wouldn't have been germane, it's being attached. It's under the potable water and wastewater system permitting, that same bill we're already talking about. So it applies to potable water, wastewater system permitting, as well as wetlands permitting. And it's really in the case that the problem it's trying to solve is somebody puts in their septic system on their property and inadvertently did so in a wetland or in a wetland buffer and didn't know. And what happens later? What happened? How does that get addressed? And currently, my understanding is the only way that would come up, we heard from the agency of natural resources, that the way that would come up is that somebody would make a complaint because they're not out enforcing, they're not out checking every septic system install for whether it was actually related to a wetland. And so if nobody noticed and they got installed, somebody would make a complaint. And if they make a complaint, A&R is required to do something to look at that complaint and investigate. And they have, then A&R has enforcement discretion on whether to enforce it all, and what level of fines to utilize, or whether to require a permit or a permit amendment. So A&R has that. I'll just say this is sort of the bottom line of why we voted this unfavorable, is A&R already has that enforcement discretion to deal with that situation. And that situation could happen because somebody just totally didn't know, and it really did not. There wasn't very clear signs of a wetland at the time and they did that. But it also could happen because they really don't want to have to get a wetlands permit. So you can understand there's sort of a variety of situations in which that could happen, which is why there is enforcement discretion. I still have a hard time fully comprehending the language here, but it says that in this case, that there would be an exemption. And in that case, no matter why that happened, the exemption would be that they don't have to get a potable water supply or wastewater system permit or permit amendment, or a wetlands permit or a wetlands permit amendment, or amendment to their wastewater side. It's a little confusing. So because this is in sort of the wrong section of statute, it has a couple of really unintended consequences. One is maybe an intended consequence, and that I just was referring to, so I'm not being super articulate on this, but creates a potential incentive for somebody to be fine ignoring a wetland and saying they didn't know about it, frankly. So while it certainly applies to people who just were really trying to do the right thing and made a mistake and didn't understand what to look for, it also applies to people who would utilize this tool so that they don't have to get a wetlands permit. That's one unintended consequence. And then the other one is really related to this sort of being in the wrong place in statute. It creates pressure or responsibility for the engineer or the contractor who's doing the wastewater designing and install, that this sort of affects their licensure. And they would be potentially on the hook for not having delineated a wetland. It's not their area of expertise or responsibility currently. And because it's related to wastewater and water statutes, those engineers and those professionals would somehow also have to be responsible for this, for their client. And that is, we didn't get a lot of testimony other than, we didn't get any testimony except from our legal counsel who said this is a potential really big problem. How big of a problem and how engineers would want to deal with that, but it certainly, we heard from legal counsel, could mean that wastewater systems in particular, getting the permit and the design work from your engineer could take much longer because of this new need to be paying attention to wetlands and wetlands delineation. It's really meant for a whole nother permit program. I'll stop there.
So I'll follow on with the deputy commissioner, joined us this morning of DEC, and he just.
What is DEC?
Department of Environmental Conservation. So their response is that these instances are, they do happen, what Representative Chapin talked about, but they're very fact specific. And so they're just really, they don't happen a lot, but they're very specific to what's going on the site. He had concerns about the misuse of this, which Representative Chapin kind of mentioned. They can't know if it's an intentional or unintentional disregard of the statute. And very much concerned about unintended consequences, and it opens the door to the future rather than retrospective solutions to an existing problem. So overall, they were not looking favorably on this amendment.
Great, thank you. And the vote again was,
This one was 7-3-1 unfavorable.
any questions? Candace.
Thank you, Candace White from Waitsfield. I just have a question. So if a house exists, it has a current operating septic system and mapping identifies a wetland that the people who originally installed the septic system didn't know existed. I think our wetlands technology and ability to identify them has gotten a lot better in recent years. So what would happen if my house has a septic, existing septic that then gets mapped as a wetland? What would happen to a homeowner in that situation? Do you?
My understanding is somebody would have to make a complaint and A&R would have to come look at it. They would have to confirm and do their own wetlands delineation, and then they would have to choose to enforce upon that homeowner. And then there would be potentially a fine or a permit required.
So even if the homeowner put in the septic system at a time that they didn't know was a wetland, I'm just, again, like thinking about wetlands science now, I think it's a lot better than it was 30 years ago. So the idea of someone newly discovering that a wetland exists where they may not have kind of even known what a wetland was, they would perhaps receive a fine or even further, like have to put in a new septic. I'm just trying to understand like what could potentially happen to a Vermonter, and of course everyone's concerned about costs and so forth. So
I guess I would say you're speaking exactly to the site specificness of each of these interactions and the enforcement discretion and the reasonableness of it. And the agency has discretion to use common sense. If it was one that wasn't there, or if your septic system isn't failing because of it, I suspect no one's gonna know or ask. I mean, we know that wetlands we update the maps every 5 years. I think a delineation is good for 5 years, so.
thank you.
Any other questions?
Brett Maslin, this amendment came briefly to Ways and Means this morning, and we decided that we really didn't have jurisdiction over it for a couple of reasons. And so didn't vote on it, but I'd like to say for everybody here, waterborne pathogens are really a serious matter. I suspect that the only person here who's had cholera. That was a very long time ago, and it wasn't in Vermont. But I just have to remind everybody, waterborne pathogens are no joke, and we need to get it right. Thank you.
All right, any other questions? Okay. If you have any questions, let us know. We are going back on the floor, so I encourage everyone to get up there. You heard the votes. We encourage you to stick with the committee, and we'll see you on the floor.